Ma'am, you can shake your head all you want. If you want to talk in my courtroom, you don't get to talk here. And you can take yourself out into the hallway. You hear me? Am I understood? I appreciate you guys wasting the paper and the ink. Those have no bearing. I'm going to make my call based upon what I see, what are the facts of the case. Is sort of makes a lot of it in my mind sort of statements of ignorance as to where they're coming from and conclusions that then come through. So I would suggest to those that may want to write to the court or information that they work through the appropriate ways of doing that. Send it to counsel. Let counsel decide if it should come before the court, because otherwise, again, it's not going to have any bearing, certainly not at this stage.
Your Honor, Elvis for the people.
Your Honor, Sunita Dadamani on behalf of Mr. Calhoun.
Was there anything from either side, or did they? Well, before you begin, let me just say a couple of things so that I'm not sure that people sometimes understand how courts work. But I'll speak certainly for this court and this judge. The decisions that the court has to make are certainly balanced upon certain things. I've received a number of communications not coming through the parties. I've shared those with the parties. But people should understand that those don't sway me one way or another. The court's decision, while we live in a country that's democracy, so it says, my decision is not a democratic thing. I don't go on votes. While I appreciate people's opinions about things, some of which I may vehemently disagree with, the way to get that is those that may want to get things through the prosecutor's office, who feels that they're on that side of the issue. There are victims advocates and others that can get that communication to the court, and in a manner in which counsel can look at it and determine whether or not that's something that should properly come before the court, because they know. And from the defense side, same thing. So while I appreciate you guys wasting the paper and the ink, those have no bearing on me. I'm going to make my call based upon what I see, what are the facts of the case. It also, I will just say, I read every one of them. And with all due respect, some of the comments, and I say this, and with all the respect that I can possibly muster, that they're not factually, things aren't factually based. The facts that some of these things are predicated on don't exist in this case, which is sort of makes a lot of it, in my mind, sort of statements of ignorance as to where they're coming from and conclusions that then come through that. So I would suggest to those that may want to write to the court or information that they work through the appropriate ways of doing that. Send it to counsel. Let counsel decide if it should come before the court, because otherwise, again, it's not going to have any bearing on me. Certainly not at this stage. I also am troubled because we are at a stage where the court is just dealing with bond consideration. And there are statements that are made that have flipped everything about American jurisprudence on its head. Because there's this presumption that Jules is guilty. Folks, understand something. He has not been convicted of anything. Nothing has come before the court that has rendered any decision about any bit of his conduct. And I don't know myself in terms of the evidence that's there, whether or not that evidence is going to be sufficient that a conviction would even occur. But everybody is quick to just presume he's guilty. And maybe people should take a moment based upon what I see in these letters and reflect upon that. Because some of this, while they try to couch it in other terms, and I say this in a respectful way to Jules and others like him, some of the presumptions are being made that he is something because he's different. It's not how we work. That's not how this court works. That's not what we don't do things to people because they may be different, because they may conduct themselves in different ways. I am looking solely at the allegations that are in the case, the facts, and the facts of the case. I'll emphasize that word, the facts of the case as they relate to these particular charges. So I would ask that you just refrain from doing that. If you want to send it, you send it. They're going to end up the same place that everything else is and going to have the same impact on this judge. I've been doing this a while. I know what I'm doing. I get it all. And I will just say as a personal note, I'm dismayed as a family of educators and being an educator and professor myself with some of the presumptions of people who presume to be or say they are educators. Because sometimes the primary job of an educator is in a room full of kids or a room full of students. You have to deal with those that are of the least and those that are of the highest. And you have to do for both of them. And some of the statements that I see from some of the teachers, it distresses me, being a product of the Ann Arbor public school system myself, that there are teachers that believe that because Jules is who Jules is, it seems they don't want to deal with children that may be like him. That is what I see. Ma'am, you can shake your head all you want. If you want to talk in my courtroom, you don't get to talk here. And you can take yourself out into the hallway. You hear me? Am I understood? So what I am going to do and what I've elected to do is to adjourn this hearing. There may be things that I may request of counsel, such as a full threat assessment to figure out where this is and what threat, if you will, Jules actually poses. So I may be requesting that. I haven't made that final decision. I'm going to adjourn the probable cause hearing and a determination on the bond and its conditions. I'm going to adjourn that to September. I was going to do the 3rd, but 10th. The 3rd doesn't work for council, so I'm going to adjourn this to September 10th, 2026.
Thank you, Judge. May I request that it be in the morning section of the document?
I want it morning.
If it's possible. I have to be back in Detroit at 5, and I'm not sure I could make it if we set it for the afternoon.
It's like today, yes.
Thank you, Judge.
Ms. Valtez, you have any?
Not at all, Your Honor.
I'll set it at 9, and maybe Ms. Weidling, we could try to make it toward the noonish hour so we can get through our block of chaos and then get.
Judge, appreciate accommodation.
Is there anything else?
No, Your Honor.
No, Your Honor.
All right, bond will continue. Thank you. Thank you, Jules.
Thanks. Bye.
Bye-bye. 14A. Ann, thank you very much. Anna, thank you very much. Lily, thank you very much. Razan, thank you very much. I don't know if Mallory was here. Thank you, Mallory. Mr. Bates, thank you. 14A stands adjourned.
The record, please.
Davion Smetler.
Counsel, this is your motion to withdraw.
That is correct, Your Honor.
Mr. Smetler, you have any objection to counsel withdrawing?
No.
All right. Do you have other counsel in place?
No.
You were retained on this, counsel.
That is correct.
I don't think PD was on it previously. He's substituting for PD.
Correct.
See? Okay, I just wanted to make sure the public defender did not.
I can explain the procedural history, Your Honor. I believe that there was he originally had a public defender, and then there was a miscommunication with regards to notice. Mr. Smetler failed to appear. He retained myself for this matter as well as a matter in Wayne County. I asked the court via documented notice to quash the warrant and to allow myself to substitute in. Since then, there's been a breakdown of communication and defense counsel's withdrawing.
Got it. Court will grant the motion to withdraw, discharge this attorney from any further obligation to this case.
Thank you, Your Honor. May I be excused?
You may. So, thank you. And the court this becomes a public defender case.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Smetler. Your Honor, based on that, we would ask for an adjournment of the probable cause conference.
Go ahead.
Mr. Smetler, if you could please contact the Public Defender's Office and make sure that the contact information we have for you is correct in our system, and then we'll reach out prior to your next court date.
Okay. Thank you. I appreciate you.
Yeah. Do you need me to give you that number, or do you have the information?
Yes, please. So I could just write it down right now with a pen.
Sure.
Okay, I'm ready.
222-6970.
222-6970.
And I will adjourn this case to September 3rd, 2026, 9 a.m.
Okay.
Thank you.
Thank you, Your Honor.
Don, thank you, sir. Are these? Is that you, Andrew? That's it? What did you say? I don't have it yet. You have it. Okay. All right. So I think what I have left is Calhoun. I'm going to take a break. It's been a day. Your name, sir?
Your Obama Sanders.
Your Honor, this time people are unable.
The defense move to dismiss, Your Honor.
For being unable to proceed. This case is dismissed on the prosecutor's motion. All right.
No problem. Well, that's what's in here. Just barely see some coming.
Well, what's mine?
Miss Perry Norm. Agreement.
All right. You're all set?
Thank you, Your Honor.
Court does call the case of the people versus Kelvin Jones.
Morning, Your Honor. Sign language interpreter.
Yes. Yes. She can come up this way. She's facing him. May I have them sworn?
Raise your right hand. Do you solemnly swear or affirm that you will interpret accurately, completely, impartially, using your best skill and judgment, and to translate from spoken English into American Sign Language, and from American Sign Language into spoken English in the matter now before the court, so help you God?
Yes, I do. Yes, I do.
Ms. Lindy, Ms. Rose?
Yes.
Thank you.
Good morning, Your Honor. Raymond, the cook for the people.
Good morning. Good morning, Judge. Christopher Quinn appearing on behalf of Mr. Jones, who's present.
Your Honor, the people are unable to proceed.
Defense would move for dismissal.
People being unable to proceed, this case is dismissed without prejudice. Thank you. Thank you.
Thanks.
Court does call the case of the people versus Grant Duche.
Good morning, Your Honor. Raymond Cook for the people. This is a key D case. I can go grab them again.
Buckovich. Do I have an email? Sir, state your name.
Grant Matthew Duche.
Maybe I'll tie it into the table.
I think it's a reprieve. After this for a few minutes.
Assistant Public Defendant Nicholas Buckovich on behalf of Mr. Duce.
It's already stated his name.
Thank you, Your Honor.
All right.
Unable to proceed.
At this time, Your Honor, the defense will move to dismiss.
People being unable to proceed, this case is dismissed without prejudice. Thank you. Thank you, Miss.
Thank you, Your Honor.
Got it. Court does call the case, people versus Brianna Force.
Your Honor, Raymond Cook for the people. She was inside room.
Now Buckovich is here.
I can walk out.
Well, I might want you to, but not right this second.
Judge, should I put my name on the record?
Yes, please. I've called the case.
Everything was at that point. Good morning, Your Honor. Wendy Barnwell, P42505 on behalf of Miss Brianna Force.
Sure.
She's not here yet. I know she was taking transportation from Detroit to Ann Arbor.
Here.
In the process of doing that, or?
I didn't get to connect with her. I just came off of a Zoom for a court. But we spoke earlier this week in detail.
Your Honor, this is an incident where previously this case had been set. Neither the victims nor the defendant failed to appear. Again, the victim did say that people are unable to proceed. I would leave it to the court's discretion whether the court wants to issue a bench warrant or dismiss on motion from defense due to the people being unable to proceed.
Your Honor, I will try. I would ask that you not issue a bench warrant because I will try and connect with her now.
I'll tell you what, is there going to be any objection to me proceeding on defendant's motion to dismiss in absentia of the defendant?
No objection from the people, Your Honor.
Thank you, Judge.
If this case is, people being unable to proceed, the case is dismissed
Thank you.
on defendant's motion. Really did think I was going to issue a bench. Never mind, don't answer. All right. Don't answer because you're going to hurt my feelings. Court does call the case, people versus Anthony Johnson.
Morning, Your Honor. Raymond Cook for the people.
And good morning, Your Honor. Edward Drugas, on behalf of Anthony Johnson, I'm standing in for the attorney of record, Hugo Mack.
Anthony Johnson.
Thank you.
Your Honor, people are unable to proceed.
And I would move to dismiss.
People being unable to proceed, this case is dismissed on the defendant's motion without prejudice.
Thank you. Thank you, Your Honor.
Court calls case of the people versus Mohammed Mufti.
Morning, Your Honor. Raymond Cook for the people.
David I. Goldstein appearing on behalf of the defendant.
I'm Mohammed Mufid.
Your Honor, the people are unable to.
Move to dismiss, Your Honor.
For being unable to proceed, this case is dismissed. That is without prejudice.
Thank you, Your Honor.
Thank you.
Court calls case people, well, the court calls case people versus Jason Pope.
Morning, Your Honor. Raymond Cook for the people.
And good morning, Your Honor. Edward Dukas on behalf of Jason Pope, who is approaching.
Hi, Your Honor. Jason Travis Pope. Thank you. I'm doing well.
People are unable to.
Dismiss, Your Honor.
For being unable to proceed, this case is dismissed. That's without prejudice. Thank you.
Thank you, Your Honor.
Court calls case people versus Kyle Suwelski.
Morning, Your Honor. Raymond Cook for the people.
Morning, Your Honor. Edward Dukas on behalf of the defendant.
Zawalski.
Your Honor, I don't have any problem. People are unable to proceed.
I would move to dismiss and run out of here.
I almost don't want to grant it. People being unable to proceed, this case is dismissed. That's without prejudice. Thank you.
Thank you, Your Honor.
Court calls case people versus Chance Baylor.
Morning, Your Honor. Raymond Cook for the people.
And Assistant Public Defendant Nicholas Bukovich on behalf of Chance Baylor, who is now approaching.
Your name, sir?
Chance Baylor.
Thank you.
Your Honor, the people are unable to proceed.
The defense moves to dismiss, Your Honor.
For being unable to proceed, this case is dismissed. That's without prejudice. Thank you.
So,
That's it.
after dismissing the committee corrections,
Court calls case people versus Nathaniel Flanagan.
Morning, Your Honor. Raymond Cook for the people.
Ron Brown appearing on behalf of Mr. Flanagan, Your Honor.
Morning.
Good morning.
Your name?
Good morning, Your Honor. Nathaniel Flanagan.
People are unable to proceed.
Move to dismiss the charges.
For being unable to proceed, this case is dismissed on the defendant's motion. That's without prejudice.
Thank you, Your Honor. Good luck.
Court calls case people versus Angela Hayes.
Morning, Your Honor. Raymond Cook for the people.
and Assistant Public Defendant Nicholas Bukovich on behalf of Ms. Hayes.
Good.
It does not appear so, Your Honor.
Your Honor, no candidates are unable to proceed.
And I do know Ms. Attorney did have contact with Ms. Hayes this week, so I would be asking for the court's consideration of a motion to dismiss.
People have no objection to proceeding in absentia.
Correct.
People being unable to proceed, case is dismissed. That's without prejudice. Thank you.
Thank you, Your Honor.
Court does call the case of the people versus Anthony Rabago.
Morning, Your Honor. Raymond Cook, people.
And Assistant Public Defendant Nick Bukovich on behalf of Mr. Rabago, who's now approaching. Mr. Rabago, could you please state your name for the record?
Anthony Rabago.
Thank you.
Your Honor, people are able to proceed. From my understanding, based off of communication with Ms. Perry this morning, it's going to be a joint request for an intervention. This was originally Ms. Perry's case, and she wants the ability to handle it and resolve it herself.
Is that a correct? That's a
That is the correct representation of the emails with Ms. Perry. I was CC'd on that email, Your Honor.
I'll adjourn this to the jury final settlement conference to October 16th, 2026, 9 a.m. The jury selection following that, if necessary, will be October 19th, 2026 at 8:30. Both of those proceedings are in person. Bond will continue. All right.
Thank you, Your Honor.
Thank you, Your Honor.
Court calls case People versus Tyree Russell.
Morning, Your Honor, Raymond Cook for the Peoples.
And Assistant Public Defender Nicholas Bukovich on behalf of Mr. Tyree Russell, who is now approaching.
Really?
They look comfy, Your Honor.
But unable to see.
And the defense makes a motion to dismiss, Your Honor.
Is that all you had? Don't answer. Don't answer. People being unable to proceed, this case is dismissed. That's without prejudice. Thank you.
Have a good day.
Any more of your clients look like they're going to a picnic?
I hope not.
Don't know. All right.
I haven't looked at everyone's pants, Your Honor.
Court calls the case People versus Jackson Sertivant.
Morning, Your Honor, Raymond Cook for the People.
And Assistant Public Defender Nicholas Bukovich on behalf of Mrs. Sturdivant, who should be approaching.
Thank you.
Your Honor, I received some additional information from Ms. Perry yesterday that leads me to believe that prosecution is no longer in public interest. I would move to dismiss.
No objection.
No objection, Your Honor.
Case is dismissed on the prosecutor's motion without prejudice. All right. Thank you, sir. Thank you. Court calls case People versus Lakrita Thompson.
People.
And Assistant Public Defender Nicholas Bukovich on behalf of Ms. Thompson.
People are unable to proceed and have no objection to having this case heard.
Now, I do know Ms. Kearney did have contact with Ms. Thompson earlier this. I would be requesting the dismissal based upon the prosecution's lack of ability to proceed.
Being unable to proceed, this case is dismissed. Court calls case People versus Basola Lambo.
Conrad Silver on behalf of School Township.
And Assistant Public Defender Nicholas Bukovich on behalf of Ms. Lambo, who is now approaching.
Hello,
Hello, your name?
Basola Lambo.
Thank you.
We do have an agreement, Your Honor.
All right.
And count two of double parking.
Okay.
So the responsibility that added count two, if you accept it and dismiss original charge.
Got a quick statement?
Yes, Your Honor.
Hey, Ms. Lambo, do you admit responsibility to the fact that on or about good way to start out the new year, January 1st, 2026, location of Torrey Avenue, Pittsfield Township, Washington County, State of Michigan, that you double parked a motor vehicle?
Yes, Your Honor.
All right, court will accept that. Admissions, count two, count one is yes. Fines and cost of $180. When can you get that paid?
I can pay it today. In full.
I like that client.
This is a wonderful answer.
It was the best answer in the asked.
And spraying pants.
Wow. Okay. All right.
I need everything going for me today.
Pay that out at the counter, man. All right. Have a great weekend. So the record's clear. Everybody has had pants thus far. Court calls the case People versus Jalen Washington.
Your Honor, Raymond Cook for the People.
Ron, Mr. Washington.
How you going?
I'm doing great. How you doing?
All right.
All right. State your name.
Glenn Washington.
All right. I have before me a plea form that indicates that the defendant will be pleading, it looks like, to the stated count two. Hang on a second. Well, let me make sure. I have as the set count one of operating while intoxicated, count two of carrying a concealed weapon while It's cut off.
Well,
While under the influence. I see what it is. Okay, I read that wrong. So he's going to be pleading to the carrying under the influence, the 93-day offense, which is stated count 2, and then also an added count 3 of operating while visibly impaired. He'll be pleading guilty to both of those counts. The second one being also a 93-day misdemeanor. In exchange for that, count 1 would be dismissed. There's also a sentence agreement to prosecutor's deferred sentence under count 2. That's the court's full understanding of the agreement.
that's correct, Your Honor. Just for some additional clarity, the state count 2 of carrying while under the influence, not the added second count. I think I really cleared on the form. I just want to make sure.
Yeah, on the form, and that was my mistake. On the form, it is carrying under the influence as the stated count 2 that he would be pleading to, and an added count 3 of operating while visibly impaired.
That is all correct.
Yes, Your Honor, that's fine.
Correct. May I have him sworn?
You solemnly swear in the affirm the testimony you're about to give today. It's the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your first and last name for the record.
Jalen Washington. All right. Sir, it is this court's understanding that you're going to plead guilty to 2 misdemeanor charges. Is that your understanding?
Yes.
The first is the stated count 2 of carrying a weapon while under the influence. That's a misdemeanor punishable by up to 93 days in jail, $100 fine plus court cost, and mandatory forfeiture of the weapon or device. You understand that? And also to the charge, an added count of operating while visibly impaired. That's a misdemeanor punishable by up to 93 days in jail, a $300 fine plus court costs. Court could order any rehabilitative services or community service the court deems necessary. The court could also order your people immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that, sir? Understanding all of that, you still wish to plead guilty?
Yes.
To the charge of carrying a concealed weapon under the influence or carrying a weapon under the influence, how do you plead? To the charge of operating while visibly impaired, how do you plead? Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
Signed an advice of rights form, is that correct?
Yes.
Any questions regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right. Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will. And because you believe that you're guilty of these offenses?
Yes.
On the date of November 2nd, 2025, at the location of I-94 near Carpenter Road in Pittsfield Township, Washington County, State of Michigan, were you operating a motor vehicle?
Yes.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes.
What'd you have and how much?
I had 2 cups of Bacardi.
2 cups of Bacardi? Okay, were you stopped by the police or was there an accident?
I was stopped by the police
Why'd they stop you?
because I was swerving.
Swerving? All right, you're not challenging the right of the police to stop you in this case, are you?
No.
All right. Were you ultimately arrested?
Yes.
Were you taken to the hospital? Was there a blood draw? And what were the results of that? The results of that blood draw were a 0.111. Is that correct? All right. And you have any reason to dispute those results?
No.
Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes.
At the time that you were operating that motor vehicle, did you have a weapon in your possession?
Yes.
What'd you have?
CZ.
Pardon?
A CZ.
Okay. And where was that located?
In my glove compartment.
Okay. You didn't have authority to carry it in that fashion, did you?
One more time.
You didn't have authority to carry that weapon in that fashion.
No.
All right. I think that does it. Sir, I do have to advise you that if between the time I accept your pleas and the time of sentencing, if you commit misconduct as defined under the Michigan court rule, you would not be entitled to withdraw your plea court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None from the people?
No, Your Honor.
And have I complied with the court rule?
Yes, sir.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to counts 2 and 3. Count 1 is dismissed. Defendants referred to Von Swartz, well, actually, because of the other charge, referred to probation, Von Swartz for an alcohol screening and assessment, and the victim's impact panel. Sentencing in this matter will be September 9th, 2026, 9 a.m. As your invite indicates. Bond with its conditions.
Thank you, Your Honor.
You, sir, on your way out, stop down at the hallway there on the left at my probation department. Check in and get the process started.
Okay.
All right. Thank you, sir.
Thank
Have a good weekend. Court calls the cases of the people versus Devontae Smith.
Carolyn Foster Tucker on behalf of Devontae Smith. You see.
Your name?
Devontae Smith.
We'd ask for a dismissal of both cases.
Okay. We have the violation. Sure. Sure. Oh, sure. Got it. I think we addressed those before. I'll do it this way. First thing I'll do is I'll cancel the bench warrants because bench warrants had been issued because you were in the exclusion zone again, young man, after I gave you the warning. You remember that?
Yes, I do.
It's a good thing they didn't get you before you got here today. I'll cancel the bench warrants. Case. People being unable to proceed, this case is dismissed. Both cases are dismissed.
Thank you, Your Honor.
No prejudice. Thank you.
There's any.
That's it?
And Gibson, I think we can call his 2 cases.
Jail actually needed a minute. Jail is not ready right now.
Okay.
I believe we're also ready to call Kasham. Caleb Kasham.
Now that's.
Also, Mariah Don Mariah. She here. Okay.
Court does call the case, people versus Caleb Shaw.
Morning, Your Honor, Raymond Cook for the people.
David I. Goldstein appearing on behalf of the defendant. Your Honor, I spoke to Mr. Kasham this morning. Apparently, he and his parents were the victims of an attack by some savage lettuce. His parents are in the hospital, and he also has the virus, although he is not in the hospital. And he said, given a day or two, he can get proof of that. But I just found this out about maybe 15 minutes ago. And he has appeared every time up until now.
Yes.
So I'm going to ask if the court would consider an adjournment. I think the matter is going to be resolved. I don't think it's going to go to trial.
Having had firsthand experience with some particularly savage lettuce, I will leave to the courts to swallow.
Wow, really? I threw all mine away and
I just stopped going to Taco.
A salad.
I just stopped going to Taco Bell. That's
Well, got lettuce. I'm not doing it. I've always thought lettuce was useless anyway. It takes more energy to chew it.
Listen, I was having a problem with Taco Bell long before this thing with the.
All right. I will adjourn, given those circumstances, jury final settlement conference to October 16th, 2026 at 9. Jury selection, if necessary, following that, October 19th, 2026 at 8:30. Both of those proceedings are in person.
Thank you, Your Honor. Thanks, Ray.
Tell your client, I hope he feels better.
Thank you, Judge.
And I did something. Let's go someplace. Court calls the case People versus Mariah Denell.
Your Honor, Raymond Cook for the people.
Good morning, Your Honor. Christine Sachs for Mariah Donnell. Mariah Donnell. It's all right. That's okay. I'm used to it. Mariah Donnell.
No, you're okay, ma'am. You were just waiting to get up there to criticize me about something.
To criticize you?
It have to be that, wasn't it? Is that
Criticize you?
huh?
Criticize you about something? Would I do that?
Of course not.
People are unable to proceed.
Okay. I'm almost gonna not grant it, Saxon.
Defend
But
to dismiss without prejudice.
people being unable to, and its motion to dismiss, granted, that is without prejudice. Without me.
Thank you, Your Honor.
Court calls case People versus John Smith III.
Your Honor, Raymond Cook for the people.
And Assistant Public Defendant Nicholas Buckovich on behalf of Mr. John Smith, who is now approaching.
Okay.
John Smith III, Your Honor.
Thank you.
Your Honor, people are unable to proceed.
Defense moves to dismiss, Your Honor.
For being unable to proceed, this case is that's without prejudice. Thank you. Have a good weekend.
Thank you. Okay.
Does Miss Saxon have something else, or can she leave my court? But no, look, I'm talking to my staff. Court calls the case People versus Devon Gibson, 2 cases.
Morning, Your Honor, Raymond Cook for the people.
Good morning, Your Honor. Edward Dukes on behalf of the defendant. Standing in for the attorney of record.
Yes. You're standing in for Mr. Sachs?
Yes, Your Honor.
Your name, sir?
Edward Gibson.
People are unable to proceed on these.
I would move to dismiss.
And Claire, you have no objection to Mr. Dukas stepping in?
Yes.
No, sir.
Okay. People being unable to proceed in either matter, these cases are dismissed without prejudice.
Thank you, Your Honor.
Thank you, Your Honor.
You're welcome, sir. What? That's it?
Oh.
And she's. We can be. And also.
Goodbye, Miss Sackman. Have a good weekend. Court does call the case of the people versus Demond Bransford.
Morning, Your Honor, Raymond Cook for the people.
Good morning, Your Honor. Trovia Star on behalf of Mr. Bransford. Mr. Bransford, state your name.
Demond Bransford.
I have before me a plea form that indicates that the defendant pleading as charged to the count of assault and battery, the 93-day offense. There is a sentence agreement to time served.
Correct, Your Honor. Some additional context. This was an assault that occurred at the jail. And it did a month or two in custody on this and some other matters. He's sentenced, I believe, out on 15th on the 18th
Correct.
of August for an attempt resisting and obstructing the 1-year misdemeanor out there. My understanding he's also on probation on circuit court already. I didn't want to be on 3 different courts of probation, which is why people were willing to time served my costs.
And that is correct, Your Honor. The victim was the previous case that you just called.
Got it. Okay. I don't, given the circumstances, I don't think there's going to be, I'm certainly not going to have an objection, but he'll still have to go through the probation department to see what happens because it's a victim's rights case.
Yes, Your Honor. I did explain that to my client.
Okay. May I have him sworn?
Do you solemnly swear and affirm the testimony you're about to give to the court is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name for the record.
Demond Bransford.
Thank you. Sir, it is this court's understanding that you're going to plead guilty to the charge of assault and or assault man. Is that correct?
Yes.
That's a misdemeanor, punishable by up to 93 days of jail, $500 fine plus court costs. You understand that?
Yes.
Still wish to plead guilty?
Yes.
To that charge, how do you plead?
Guilty.
You understand that by pleading guilty, you'll not have a trial of any kind?
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Okay.
So yes.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
Yes.
Were you on probation at the time of this offense?
Yes.
All right. Just so that we're clear, is that one of the probations?
That would be
The circuit.
Circuit court probation. All right. I do have to advise you, sir, that your entry of a plea in this case could then be considered a violation of that probation. You understand that?
Yes.
As such, if it is considered a violation, that court could sentence you to the maximum allowable under those other charges. You understand that?
Yes.
Understanding that, you still wish to plead to this charge.
Yes.
Has anybody promised you anything to plead
No.
other than what's been stated? Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will
Yes.
and because you believe that you are indeed guilty of this offense?
Yes.
On the date of March 24th, 2026, 2201 Hogback, the Washington County Jail, what'd you do involving a Devon Gibson that makes you think that you're guilty?
I assaulted him.
How did you assault?
Oh, I punched him.
Punched him?
Yeah.
All right. You didn't have his permission to do that, did you?
No.
And it wasn't an accident on your part?
No.
Intentionally, correct?
Yes.
Sir, I do have to advise you that if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None from the people?
None from defense, Your Honor.
And have I complied with the court rule?
Yes, Your Honor.
Satisfied, Your Honor.
Court will accept the defendant's plea of guilty to this charge. Defendant's referred to probation. for a pre-sentence investigation and report. Sentencing in this matter will be September 9th, 2026, 9 a.m. Bond in this case will continue. All right, thank you. Sir, stop down at the probation department on your way out there on the left, just so we can get the process started. Okay?
Okay, thank you.
I watch on YouTube, all of it.
Look,
Never worry.
ma'am. Thank you so much for telling me that. I do appreciate that and all your kind words. All right. You do the same and have a blessed weekend.
Judge, can I get your autograph?
Yes, on the warrant I issue for you, you can have it. Thank you, Mr. Starr. Yeah, I told you I'm a nice person. Yeah. Despite all those things you said. Okay. Court does call the case, People versus Caitlin Davids.
All right, so, okay, Bill Township.
Assistant Public Defendant Nicholas Buckovich on behalf of Ms. Davidson, who is now approaching. Can you please state your name for the record?
Caitlin Davidson.
Thank you.
And we do have an agreement.
Okay.
Get a bit responsibility. How to go again. If you accept that, admission and dismiss the original charge. Oh, excuse me, the original. So in case 0785, I'm gonna add count 2, etc. Thank you. The parking. If you accept that admission, I move to dismiss the original charge as well as dismissing case 0786.
Got it. Okay.
That is also our understanding of the agreement, Your Honor.
Ma'am, do you admit responsibility? In fact, that on or about June 6, 2024, location of Gulfside Road, Pittsfield Township, Washtenaw County, State of Michigan, that you double parked a motor vehicle.
Your Honor.
The court will accept that admission in case ending in 0785. That's as to the count 2 in that case. Count 1 is dismissed as well as the case ending in 0786. Fines and cost $180. When can you pay that?
Paid today.
I know, that's 2 in a row.
Dang.
Amazing. And you take credit for that, right, Buckovich?
Of course.
All right. You get blamed for everything, so take credit.
Take whatever I can. I understand.
All right. Thank you, ma'am. Have a great week.
Thank you, you too.
Have a good rest of your day, Ms. Davidson.
Just. No, I'm gonna take a break, but I don't know what, there's other people staring at me.
Ready on June. Yeah, what was the other one we discussed?
Usually, Ryan.
And then did want to call Cleveland, see who plays out.
Be great.
So Jude Bryant in Cleveland.
Court does call the case, People versus Orita Bryant.
Morning, Your Honor, Raven Cook for the
And Assistant Public Defendant Nicholas Buckovich on behalf of the client, who is now approaching.
Your name?
Bryant.
current people are unable to proceed.
Your Honor, the defense moves to dismiss.
Okay. Where's her? This is another one where we had. Record to reflect we had a bench conference in this case. There's a bench warrant currently outstanding. There's community corrections violation that I think you've had an opportunity to review that with your client. And ma'am, do you admit to the violations?
Yes,
Yes.
okay.
I'll sentence the defendant to $250 for the violations. You can pay that today, is that correct?
Yes, sir.
Pay that today. And then people are unable to proceed and you agree to dismiss.
Yes, that's correct, Your Honor.
So upon the payment of the $250, the case will be dismissed.
This is the clerks.
All right. Thank you.
Thank you.
No problem. Once she pays the $250, the bet, even
Hey, can I see that? Say what?
he was asking about the bench.
Oh, you still want it? Oh, okay. I'm just checking. If you still want it, I'll let it hang out there. I did not say that, so I should say that. Thank you for reminding me. I'll cancel the bench one. You're welcome. Court calls case people versus Anaya Cleveland.
Your Honor, Raymond Cook for the people.
And Assistant Public Defendant Nicholas Bukovich on behalf of Ms. Cleveland, who is now approaching.
Your name?
Anaya Cleveland.
Thank you.
Your Honor, this is the day and time set for final settlement conference. The victim on this case reached out to our office yesterday, indicating that she would be unable to be present today because she could not afford to take time off of work. She has been communicating with our office and reached out to us. If the court would excuse her appearance, that people would be able to proceed, but I do understand the court does have a requirement that victims be present in person. Nevertheless, given that.
But they've been in contact with your office.
Yes, they called us yesterday. I can see how much contact we've had before yesterday. We just want a second. Let me just double check that my victim advocate. So here's that yesterday was the first time that actually she did reach out.
But she did reach out and could explain it. Okay. Well,
Your Honor, today is the time and day for final settlement conference. As APA Cook indicated, typically it is required that the complaining witness be here. This contact was not made until yesterday. I do understand that they do have time to make contact. However, I would expect that the prosecutor's office probably did reach out multiple times and earlier. So I would be asking, based upon the complaining witness's failure to appear today, for this case to be dismissed.
I'm a bit reluctant to do that. People versus Min Du.
Morning, on Raymond Cook for the people.
And Assistant Public Defendant Nicholas Bukovich on behalf of Ms. Zhu.
Hello, your name?
Ming-Chu.
Okay.
The defense moves to dismiss, Your Honor.
For being unable to proceed, this case is dismissed. That's without prejudice. Thank you, ma'am. All right. How many more? All right.
3 plus your recall.
3 plus.
Yep.
We don't know what's going on.
Not.
What's Foster Tucker doing lurking in my court?
I think she needs you.
She needs me to take a break. I need the judge to get off the bench. I gotta do stuff.
An opportunity to speak with Ms. Foster Tucker to see if we can resolve her case if the court can give it.
Okay. I thought she was gonna start a brawl or something. She wanted me out of the way.
He failed to appear on Wednesday. Motion to withdraw. I don't know if he's here. It is already in bench warrant status.
The case is in bench warrant.
Yeah, you issued it on Wednesday. It both matters.
Oh, but then left it on the docket to see if he would appear. Court does call the cases of the people versus Daryl Green.
Canada still on the it's still township.
Raymond Cook for the people on the file ending in 0249.
Ron Brown appearing on behalf of Mr.
On Wednesday, I had institute bench warrants in these cases. I let the jury final settlement conference election remain on, hoping that he might appear. So defendant failed to appear. We will leave the bench warrants outstanding.
Thank you.
This one isn't this, but this is Miss Ford. The other Miss Ford, she indicated she was.
Who's?
Um,
Okay. Wait, okay.
There's amount of organization this morning. The admission from a car was removed when she went in, so she had to take a lift from the point.
Well,
He's correct.
Yes,
the whole ignition was removed? Call the case of the people versus Jacob Simmons.
You want to read the book for the people?
What, you lost your client? Seriously?
Right here, Leonard.
Okay. Oh, it's okay. It's okay. I wasn't blaming you, Mrs. I was blaming Mrs. Foster Tucker. I just say she lost a client again.
Sherilyn Foster Tucker on behalf of Jacob Simmons.
Jacob Charles Simmons.
I have before me a plea form that indicates that the defendant would be pleading to an added count to a failure to stop after a collision. The 90-day offense, upon a successful plea to that charge, count one would be dismissed. The prosecutor will recommend fines and cost sentence.
Restitution to be resolved.
Okay, and restitution to be determined. The only thing that's the court's full understanding of the agreement. I don't know, did you wish for me to set a restitution hearing now or wait?
If we could just get a sentencing date, that way the victim has time to guess documents and maybe we can reach an
agreement. But if you can't, then
yeah.
Right. Okay. All right. That's fine. All right. That's the court's full. Is that correct, Ms. Foster?
Yes, I believe it's a no contest plea. I'm not sure if that was stated.
I probably did not state.
Okay.
Yes, it's a no contest plea because I have reviewed the report. All right. May I have him sworn?
You solemnly sworn in affirmative testimony about the use of the court is the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
You lower your hand, state your name, first name and last name of the record.
Jacob Charles Simmons.
Thank you, sir. All right, sir, it is this court's understanding that you are going to be pleading no contest to the charge of failure to stop after a collision. That's a misdemeanor punishable by up to 90 days in jail, $100 fine plus court costs. You understand that, sir?
Yes, Your Honor.
All right. Do you understand what a no contest plea is?
Yes, Your Honor.
All right, two things about it I have to make sure that you understand. The first thing is it means that you're not further desirous or wanting to contest this charge. You understand that?
Okay.
Second thing you need to understand is that for purposes of sentencing, the court is going to treat you the same as though you had pled guilty. You understand that, sir?
Okay.
All right. Is your okay meaning you
Yes.
Okay. All right. I have to make sure for purposes of the way. All right. Basis for the no contest plea?
Potential civil liability, Your Honor.
All right. Sir, to that charge, then, how do you plead?
Guilty.
No contest.
Oh, I'm sorry. I don't know.
No, it's okay. It's all right.
I'm very new at this and I will not.
This is like my first day.
I will not be a veteran at this.
All right.
All
right. So let me start again.
Okay.
To that charge, how do you plead?
No contest.
There you go. You understand that by pleading no contest, you'll not have a trial of any kind.
Yes.
All right. You had signed an advice of rights form. Is that correct?
Yes.
Any questions regarding any of those rights?
Can I get a copy?
Yeah.
All right.
It'll be over there.
You have any questions regarding any of those rights?
No.
If you look on the podium, there is a copy of one. Please look at paragraph 5. Those are your rights, which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
Your Honor, he is, but not at the time of this
At the time of this time.
case.
Okay. Has anybody promised you anything other than what's been stated here today to get you to plea?
No.
All right. Has anybody threatened you or coerced you in any way?
No.
All right. You're doing this voluntarily and of your own free will?
Yes, of course.
All right. Court has been provided and has reviewed Pittsfield Township Department of Public Safety Court for their case number 25-21156. Counsel, any objection to the court having reviewed that?
None from the people?
No, Your Honor.
All right. Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, I do have to advise you that if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None from the people?
No, Your Honor.
And have I complied with the court rule?
Yes, sir.
Yes, Your Honor.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Defendants referred to probation for pre-sentence investigation and report and potential determination of restitution. Sentencing in this matter will be September. Thank you. Court for its part also does not believe there's a conflict either in Michigan. The rules or the cases decided thereunder to the extent a conflict does exist, given the waiver, support will consent to hear the matters. Court does call the case of the People's State of Michigan versus Donald Ray Baker.
And Senior Assistant Public Defender representing Mr. Baker. Mr. Baker, would you please state your name for the record, please?
Donald Baker.
Got it. Okay. What are we doing?
Your Honor, Mr. Baker is requesting a preliminary exam.
All right. All right. Anyway, discovery is complete.
As far as I know, Your Honor.
And we would normally be setting for the 18th. What facility are you in, sir?
Don't.
Got it. We're going to have to give how much time?
He needs 4 weeks, is my understanding.
It's 4 weeks out. Jeez. Go September 1. Would people have their witnesses available September 1st?
That's true. I think the discovery is not complete. I believe that his email being to go requesting some video. So
And maybe getting paid.
if there's.
No. Is there some additional video for this matter?
I'm going to request some from agency. I'm not sure if they have it in them.
Okay, then, Your Honor, could we keep the 9/1 preliminary exam date and I'll follow up with Ms. Stover?
I will indicate that video missing, no adjournment would be granted based upon that video not being present. Preliminary examination in person, September 1st, 2026, 9 a.m. before Judge Barr.
Thank you.
Continued. Court does call the cases of the people versus Matthew Gibbons.
Assistant Public Defender Hannah Appleton on behalf of Mr. Gibbons.
There are 8 cases.
Yes. Mr. Gibbons, can you state your name for the record?
Matthew Gibbons.
Thank you.
Oh, there he is.
Your Honor, I submitted a visitation application to his facility. I'm waiting to hear back to schedule a visit. So I would need an adjournment.
All right. How long are they indeed now?
How long?
Yeah.
Um,
You don't know that.
I don't know.
Why don't I then, he's got a number of cases here. Why don't I adjourn this out then to September 3rd? All right. All of these matters will be adjourned to September 3rd, 2026, 9 a.m. All right.
Thank you.
I'll need a green sheet.
Oh, I have it right here. I forgot I didn't turn them in.
Court does call the case versus Burke. Yeah.
That's good morning, Your Honor. That's our.
Like, that name sounds
There
familiar.
are 184 cases.
We're gonna speed right through them, Judge.
Not at this rate.
Good morning, Judge.
Assistant Public Defender Chinati Carey Akinruli on behalf of Mr. Jason Burton, who's approaching.
Your name, sir?
Jason Burton.
Judge, we'd like to set this matter for preliminary exam, please.
Discovery is complete.
Yes, to our knowledge, Judge.
People have their witnesses available the 18th. Preliminary examination in person, August 18th, 2026, 9 a.m. before Judge Moore. Bond will continue. Thank you.
Thank you, Judge. Judge, can we make a note that he's going to need headphones for the next hearing, please? But I will go and tell him everything that just happened.
I'm going to suggest at the exam, just make sure that the court recorder knows
Okay.
that, and then we'll.
Yes, Judge.
Court calls case People versus Wyona Harvey.
Good
morning.
Good morning. This is Public Defender Lauren Perry on behalf of Miss Harvey, who's appearing from Kalamazoo Psychiatric Hospital. Miss Harvey, can you state your name?
Wyona Harvey.
All right. I have a August 5th report from CPF.
That's correct, Your Honor. It states that she is still incompetent but restorable, so I'd ask for an adjournment. Yes, please.
I'll set a competency hearing review date. Give me 90.
November 5th.
November 5th, 2026, 9 a.m. Yes.
Thank you, Your Honor.
All right. Bond continued. Thank you, ma'am. Court calls case People versus Choya Wharton.
Trying to know who to keep, Your Honor. Shannon. And, Toya Morgan.
Did they get him? And
Listen.
got him yet? Horton, can you state your name, please?
Troy Dean Horton.
Your Honor, I'm requesting a 2-week adjournment. I did not get through the clearance portion of my attempt to interview with him. But I do believe that I have successfully completed it, so I will be able to interview with him.
All right. Well, I'm going to go 3 weeks out. Probable cause conference will be adjourned August 27th, 2026, 9 a.m. Bond continued.
Thank you so much, Your Honor.
Thank you. Thank you, Mr. Horton.
Thank you, Your Honor.
Court calls the case People versus Angel Patel, 2 cases.
Assistant Public Defender Zach Vinny with and on behalf of Mr. Martell, who is, I believe, present via Zoom.
Got him.
Oh, that works. Can you please state your name?
Angel Martell.
State your name, please.
State it again, sir.
Angel Martell.
Your Honor, the court should be in receipt of a competency report. We would stipulate to the findings of that report and would request an adjournment.
Based upon a review of that report, the court and the stipulated evidence, court would find that the defendant is competent to stand trial. Specifically, that the defendant can understand the nature and objects of the proceedings against him and can rationally assist in his defense. Therefore, the defendant is deemed competent. And I've signed the order.
And Your Honor, we would request an adjournment for negotiations.
You want it set for what?
Or set for a PCC.
Probable cause conference in this matter then will be set. How much, Marcus? I'll set it for August 20th. 26, 9 a.m.
Thank you, Your Honor.
Got it. Court does call the case of Ibrahim Abdullah Al-Bassir.
Good morning, Your Honor. Kedma Dadush on behalf of Mr. Abdullah Al-Nasir. Can you please say your name for the record?
Ibrahim Abdullah Al-Bassir. I've called this case early. It was down at our access point. My understanding is, first of all, tested positive. We're informed from community corrections. We haven't issued the bench warrant yet for fentanyl. Was that yesterday?
Yes.
That was yesterday. Our understanding also is that you've been using this morning.
No, not this one. I just had some stuff in my pockets from using. But that was the last thing. It just in my system.
Your Honor, did
I don't.
there's still one question from the top.
I don't know that I didn't that on.
Ask for an adjournment so that we get the bond.
Given the information from yesterday's morning, be his bond. In this case, counsel approach. Right, record should reflect we've had a bench conference in this case. What I will do is I will grant the adjournment based on the information the court has, subject to a motion by the defense at this time. Also, in viewing the defendant's case, I'll adjourn his probable cause for 2 weeks to the 20th, 2026 at 9. At this point, the defendant's bond is revoked. Thank you, gentlemen.
Thank you, Your Honor.
Thank you. Let's call the case People versus Michael McKay.
Justice Dollars for the people. Kedma Dadush on behalf of Mr.
McKay, state your name, please.
Michael McKay.
Your Honor, I wanted to adjourn this case to finish plea negotiations with prosecution. I was also unable to meet with him. So,
okay.
Asking for
An adjournment.
Adjournment.
I could do the 20th. Right there, or once 27.
It's just because I had never used this facility before, so they had to get me approved and everything. So someone should be able to speak with him.
I'm going to do this, Mr. McKay. I'm going to bring out to August 27th so the attorney can speak to you, okay?
All right.
27th, 9 a.m. Thank you, sir. Court calls case of the people, Ronnie Oliver.
Yes, Ronnie Oliver.
Morning, Your Honor. J. Grant Miller, P58658, on behalf of Ronnie Oliver, who should be on Zoom.
Zoomer here.
Mr. Oliver is in the round.
Yes, to the MD.
Mr. Oliver, can you state your name, please?
Mr. Ronnie Oliver.
Gotcha. Okay, what are we doing?
Your Honor, at this point, I would request an adjournment. I've gone through all the steps to try and communicate with Mr. Oliver. I've been unable to do so. Mr. Oliver, my name is Grant Miller. I'm your attorney. You need to put me on the list so I can talk to you, sir.
Can you state your name again?
J. Grant Miller. Grant like the president, Miller like the beer.
Gotcha.
Your Honor, we're just requesting a brief adjournment so I could communicate with my client.
Okay.
Okay. I was still at the beer.
Kennedy,
August.
Wow.
Anybody else? Sorry. No, it's okay. You try to find your way to weasel in there somewhere. August 27th, 2026, 9 a.m.
Thank you, Your Honor.
Bond will continue. Not a beer. Court calls the case, People versus Renee Williams. That's it.
Public defender representing Ms. Williams.
You're on mute.
Yes.
Williams, can you state your name?
Yes, my name is Renee Williams.
Thank you. And what are we
Yes,
doing?
Yeah, we are here for conference hearing today. The court is likely in receipt of a report indicating the defendant is competent and not responsible.
That from July 21st.
That's correct.
That is the report. I don't recall the date we received it.
Yes, I have it from the 21st. So what are we going to do on this?
Your Honor, I'd ask for 2 weeks so I can see if we're going to full probate proceedings because she is in Kalamazoo, so I need to check into the jurisdictional issue.
No, Your Honor.
I'll adjourn the competency hearing then for 2 weeks. I'll adjourn that to 20th,
Thank you.
2026, 9 a.m.
Thank you, Your Honor.
Thank you. Bond will continue. All right. Thank you, Ms. Williams.
Okay, thank you.
Oh, you're very welcome. Thank you.
Court calls case, People versus Ethan Miller.
Your Honor.
Apparently also related to the
Court Judge.
What? Thank you.
Brian Bowling, Assistant Public Defender, on behalf of Mr. Miller.
Oh, is she? Boom, boom room back there.
Morning. Can you state your name for the record, please?
Ethan Miller.
Thank you.
Judge, we're asking this matter be set for an exam. I believe all discovery to be complete. There is one issue with respect to some photographs, but this is indicated to me that she received them yesterday, so we should have them shortly. So we should be good on the exam date.
We'll have their witnesses available the 18th. Preliminary examination in person will be set August 18th, 2026, 9 a.m. before me. Bond will continue. Thank you.
Thank you, Judge.
Court calls case, People versus Donald Foreman.
People.
Assistant Public Defender Jay Bellinger on behalf of Mr. Foreman, who appears via Zoom via Jackson County. Mr. Foreman, can you please state your name for the record?
Donald Foreman.
And Your Honor, I'll just make it clear on the record, I have had an opportunity to speak with Ms. Feltis about the potential for an offer. She advises that no offer is going to be had down in the district court. For that reason, I talked to my client yesterday. My understanding is that he wishes to waive up to circuit court. Is that still true, Mr. Foreman?
Yeah.
I don't know that I've got Foreman.
He's there. I barely heard him when he said his name, Your Honor, but.
Mr. Foreman?
Yeah.
Oh, there he is. Okay. You're waiving your right to a preliminary examination?
Yeah.
Is that a yes, Mr. Foreman? Can you say yes if that's true?
Yeah.
Okay.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them. Do you understand that?
I do.
You'll have to speak up. Did you?
Yeah.
Okay. You understand that you won't have that hearing and that you'll proceed to circuit court for further resolution?
Yeah.
Okay. People also waive their right. Preliminary examination having been waived, defendant is bound over on the 2 felonies, 1 in each case with 2 misdemeanors following in each case.
Thank you, Your Honor. As to that, we acknowledge receipt of the information, wait formal reading, stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea as to all 6 counts. Pre-trial will be set for
25th at 1:30 with Judge Punky.
August 25th, 2026, 1:30.
Thank you.
Bond continued. Yes, momentarily. Yeah. Court does call the case People versus Tamika Slip.
Morning, Your Honor. Christina Costantino appearing with and on behalf of Tamika Schlip, who should be appearing via Zoom. Ms. Schlip, can you use the Michigan Department of Corrections to unmute you and state your name for the court?
I heard things about you and a wonderful performance you gave in another courtroom.
Oh, thank you, Judge.
It was good.
No, oh, okay. A performance, no.
Thought I'd let you know.
Judge. For whatever that's worth.
Yeah,
I'll take it.
Miss Slip? We're trying to okay, there you are.
Hi, Mr.
Hello.
Simpson.
How you doing, Miss Slip? I'm wonderful. Doing great. Thank you.
Your Honor, this is
every time.
Judge, this is the date. This is the date and time set for a probable cause conference. We have had some negotiations between the prosecution and defense. A plea offer has been extended, but unfortunately, I have not been able to meet with Ms. Schlip. I have actually scheduled 3 different meetings with her, and she was unfortunately not brought to either of those meetings by the Michigan Department of Corrections. I have called, I have done a number of things to try and be able to meet with her, but unfortunately I haven't been able to prior to today's court date. So we are asking for a brief adjournment so that I can have an opportunity to discuss the plea offer with her. And Ms. Schlip, I hope that you heard that. I've tried to meet with you, but unfortunately I have not been able to. The Michigan Department of Corrections didn't bring you to my meetings with you, but I will be seeing you very soon.
I need a from mental health help.
I know, Ms. Schlip, and I'm
okay, Miss Slip. Miss Slip.
Yeah.
Okay, just listen. So your attorney's got to she's got to be able to meet with you. Okay. All right, we're going to try to find a way to make that happen. What, 20th or 27th?
20th, please.
No, come
So,
on.
hey, Miss Slip.
I can't do it anymore.
Miss Slip, if it helps.
Listen, I like jumped on my 14-yard dog because I didn't take my medication, and they wanted to chew me up Tylenol, and I'm allergic to it. I got bruises, fucking blue marks all over me. I can't do this anymore. I need to go to the
Slap,
forensic
Miss
center.
Slap, Miss Slap.
Yeah.
Okay.
Yes, sir.
We've seen each other a couple of times. If I didn't think that this was the right thing to do, I wouldn't do it to you, okay?
I need to go to a mental health hospital.
Okay,
I
we're gonna
need
let
to go to JPA, just county psychiatric, or the forensic center. I don't understand what I did wrong.
Okay, Miss Slab, here's what I'm gonna do. I'm gonna put this out 2 weeks like your attorney asked, and you're gonna get to talk to her. And then we're gonna try to make sure something happens on that date, okay?
You promise?
Miss Slab, I promise you I'm gonna give everything I've got to make sure we get you through this, okay?
Are you sure?
I'm
because
sure.
my cases they are done.
Miss Slab,
Time.
Miss Sleb, I've never let you down before, right? I don't plan on doing it now.
Okay, you promise?
Okay.
Do you pay
So,
these now?
as much as I can promise, I promise, Miss Slip. Okay?
I need to go get
And Miss Slip, think about it. If nothing else, we get to see each other one more time, okay?
Okay.
All right.
I love you, Mr.
All right.
Linden.
Okay, we'll see. Okay, we'll see you on the 20th. All right?
20th, how many more days is that?
That's about 14 days.
Okay.
All right.
Thank you.
Thank you. You take care of
And
yourself,
God
Miss
bless
Slip.
and keep smiling.
Thank you very much, Your Honor.
You're welcome.
Thank you, Mr.
Yes, ma'am.
Bye.
Bye-bye. Court calls the case, People versus Tariq Wilson.
Tariq Wilson.
Got it? Yep, we got you. Okay, go ahead.
George Payne, Senior Assistant Public Defender representing Mr. Wilson.
All right, what are we doing?
I'm just refreshing your memory. Your Honor, I met with Mr. Wilson yesterday and we had an opportunity to begin discussing his case. I'm asking for an adjournment so that we can have some additional time to talk about his options.
All right. You need additional time to talk with him about, you want the 20th or 20th or 27th?
The 20th, please.
20th. Probable cause conference will be adjourned August 20th, 2026, 9 a.m. Bond will continue. All right. Thank you, Mr. Wilson.
Thank you. Have a good one.
Court does call case People versus Jason Bailish. Excuse me.
Attorney General.
Good morning, Your Honor. I'm Special Assistant Attorney General Mitchell Wood for the people.
Good morning, sir.
Good morning, Your Honor. Assistant Public Defender Nicholas Bukovich on behalf of Mr. Bailish, who should be coming.
You're just going to have to be spread out throughout the day. Got a message. Your name, sir?
Jason Eric Bailish.
All right, you're waiving.
Yes, we are, Your Honor.
Sir, you're waiving your right to a preliminary examination?
Yes.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes, sir.
You understand you'll not have that hearing? You'll proceed to circuit court for further resolution?
I do.
Do the people also waive their right?
Yes, Your Honor.
Preliminary examination having been waived, defendant's bound over to circuit court on both counts. Mr. Bucket.
We'll waive the formal reading of the complaint and be standing mute.
Defendant having waived formal reading, standing mute, court will enter not guilty pleas to both charges. Pretrial will be set for
17th at 1:30 with Judge Moon.
August 17th, 2026, 1:30 before Judge Hammoud.
And
Thank you very much,
one
Your
thing-
Honor.
Thank you. What? Yes, Mr. Bukovich.
One thing for the honor, the rest of the honor, my client is waiving to pursue the offer of the AG in the circuit court, which would include waiving the habitual second offense notice on the complaint. I just wanted to put that on the record.
All right, very good. All right, thank you.
Honor.
Bond container.
From the, she's waving at you. I don't know what you're doing. She really wants that. She's waving.
Ma'am, you're waving at me. What's your name?
Jamila Bounds, Bounds.
Gotcha. I'll call your case right now. Court does call the case. People versus Jamila Bounds.
Assistant Public Defender Hannah Apple appearing on behalf of Ms. Bounds. Ms. Bounds, will you state your name for the record?
Jamila Bounds.
Thank you. Your Honor, I do have a green sheet. We're asking for a brief adjournment. We have some plea negotiations that are taking place, and so hoping to reach a resolution.
Turn the matter August 27th, 2026, 9 a.m. Bound, continue.
Thank you.
All right. Thank you, Ms. Bounds.
Thank you.
Court calls case, People versus Heather Booth.
Good afternoon, Your Honor. Raymond Cook for the people.
6 cases.
Yours.
Good morning, Your Honor. Sydney Rushing appearing on behalf of Ms. Booth. I'm in case ending 0913.
Good morning, Your Honor. Jay Grant Miller, P58658 on behalf of Ms. Booth.
Assistant Public Defender Nicholas Buckovich on behalf of Ms. Booth.
We've got a trio of green sheets for you, Judge.
Your Honor, I believe Ms. Rushing's is the most legible, so I'd suggest you use.
I assume that.
And Your Honor, I didn't even write it. Ms. Montesino did it, so that's why it's even more legible.
That's her writing. Why did she write it?
Judge, I was running a little bit late due to traffic, so of course she had my back just in case. You know, you called the case because Ms. Booth is second on the list. So I was a little worried there.
She's incredible.
Isn't she? Absolutely amazing.
Short, but incredible.
Judge,
All right.
big things come in small packages.
I'm sorry. I had to take the shot. I just took the shot. All right. And how much time did you need?
Judge, I know that her matter in Wayne County that we are kind of tracking to hope to get together is August 21st. So maybe the latter date in August or early.
Okay, latter day, 27th would work?
That would work, Judge.
That would work.
All right. Ms. Booth, I'm going to adjourn all your matters out to August 27th, 2026.
Thank you. Thank you.
Thank you.
Have a good day.
Thank you, Your Honor.
Your Honor.
Court does call the case, People versus Sarah McCormick.
Good morning, Your Honor. Andrew Siddle on behalf of the defendant, Sarah McCormick.
McCormick, can you state your name, please? She's not unmuted yet.
Good morning, Sarah Lynn McCormick, Your Honor.
Thank you. Who's her attorney? Benzo. All right. I have before me a plea sheet that indicates that the defendant would be pleading to the charge and added count 2 of use of a controlled substance, a 1-year offense. Upon our successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
Correct, Your Honor.
Ma'am, can you raise your right hand to be sworn? Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do. Yes, Your Honor.
State your name again for me, please.
Sarah Lynn McCormick.
All right. It's court's understanding that you're going to be pleading guilty to the charge of use of a controlled substance. That's a misdemeanor punishable by up to 1 year incarceration, $2,000 fine plus court costs. Do you understand that?
Yes, Your Honor.
All right. Understanding that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
I would like to enter a no contest plea or guilty. I'm just having a hard time hearing.
You're having a hard time hearing. Okay.
I can hear you.
Ma'am?
No, I can hear you. I can hear you now. It's just in and out.
Okay. All right. I was looking at your reaction. Do you want to plead guilty to this charge?
Yes, Your Honor, if the plea is accepted by the court.
Okay, well, let's see. We'll go through the facts and we'll see if I can accept it, okay?
Yes, Your Honor.
All right, I've apprised you of the maximum penalties. So to that charge, how do you plead?
Guilty?
Okay. You understand that by pleading guilty, you'll not have a trial of any kind?
Yes, Your Honor.
All right. You had signed on your behalf an advice of rights form?
Yes, Your Honor.
Okay. Do you have any questions regarding any of those rights?
No, Your Honor.
You understand that you're giving up or waiving those rights, particularly your trial rights under paragraph 5?
Yes, Your Honor.
You understand you're giving up your right to appeal of right?
Yes, Your Honor.
You're not on probation or parole at this time, is that correct?
No, Your Honor, not at all. But I did speak with MDOC parole board, and given the PR bond, I'm incarcerated due to this case not being adjudicated. That's why I'm still in custody.
Gotcha. Okay.
Yes, sir. Yes, Your Honor.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, sir. Just the court, Your Honor.
What did the court promise you?
No, just what we're reviewing, what I'm reviewing with you.
Okay,
Judge.
what I said today.
Yes, Your Honor.
All right. Did anybody threatened you or coerced you in any way?
No, Your Honor.
You're doing this voluntarily and of your own free will?
I am, Your Honor.
And also because you believe that you're guilty of this offense?
I do. I just wish to move to immediate sentencing. Yes.
Okay. I got to accept the plea. Just hold on. I got to take it step by step. Okay?
Oh, sorry, Your Honor.
No, it's okay. But you're pleading guilty because you believe that you are guilty.
Yes, Your Honor.
All right. On the date of January 12th, 2025, at the location of the Huron Valley Correctional Facility, were you in possession of clozapam?
Unfortunately, I was, Your Honor.
And you did not have a prescription for that, is that correct?
Not in custody, Your Honor. No.
Okay. And did you use it?
I did. I used it for 15 years, but I wasn't permitted to use it in Huron Valley, Your Honor.
Okay. While you were in Huron Valley, did you use the clozapam that you had that day?
I did, Your Honor. Yes.
Thank you.
Sorry.
Counsel, have I complied with the court ruling? Would it be proper to accept this defendant's plea?
Yes, Your Honor. Thank you.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Ma'am, is there anything you want to say before I impose sentence?
I just want to apologize for my inability to cope properly and the horrible decision that I made to use that with respect to my anxiety condition. I did not have permission to use that. I could have put myself, staff, or others at risk with that, Your Honor, and it has caused extenuating collateral consequences significantly in life, and I regret this probably more than anything. This is the worst decision I've ever done, honestly.
Okay, how long have you been in?
My sentence was for 7 months. I've been here 2 years, Your Honor. I was supposed to leave last July and then June 20.
Okay.
June 20.
It's the sentence of the court. Since his statutory minimum is $125, 365 days in jail, credit 365 served. All right, you're all set. This case has now been adjudicated. Good luck to you, ma'am.
Thank you so much, Your Honor. Thank you, Andrew. Thank you.
Thank you, Judge.
Thank you. Thank you, Your
Sarah.
Honor. Have a good day. Thank you. God bless you all. Thank you. Take care.
And court calls the case, People versus Dominic Brewer.
Good morning, Your Honor. Raymond Cook for the people.
Good morning, Judge Carbonell. On behalf of Mr. Brewer, who's approaching the podium, will be standing next to me. Mr. Brewer, when you get up here, please state your name for the record. Dominic Brewer. Your Honor, today is the date and time set for a probable cause conference. We are working on discovery. It's my understanding that the people are working on getting the video. I'll leave it to Mr. Cook.
I got an email this morning from the sheriff saying that the videos were processing and being uploaded. I don't see them yet in our system, but I'm hoping by the end of the day that should process.
Got it.
And I have handed up for the record the green.
Turn the matter to August 27th, 2026, 9 a.m.
Thank you, Judge.
Thank you, sir. Court calls case People versus Scott Kidney.
Carbonell on behalf of Mr. Kidney, but not with. Your Honor, we've catch up. So Mr. Kidney is currently in, last I knew he was in Livingston County. It's my understanding we tried to writ him out today, but they weren't able to produce him because he's in transport on a federal matter. The people have tendered an offer of a civil infraction, which I have been given his permission to admit responsibility on his behalf.
Oh.
That's fair.
Wow.
Yep. So we're pleading this felony down to one civil infraction for violation of the seatbelt law under 257.710 and no registration under 257.223. Both carry no points. In exchange, the people counts 1 and 2.
So count 3 is a civil infraction of what?
Violation of safety belt law.
Can you get fines for me on? And count 4 is what?
No registration under 257.223.
No proof of registration.
Yes, Judge.
All right. And on behalf of your client, you do admit responsibility to the fact that these offenses occurred on or about August 23rd, 2024 in Pittsfield Township, Washington County, State of Michigan.
So admitted.
Right. Court will accept the admissions to counts 3 and 4. Counts 1 and 2 are dismissed. Count 3. 65. Really?
Yes.
All right. Fines and costs of $65 on count 3, and on count 4, what's that? 200?
120.
Close. Fines and costs of 120. I'll make those due and payable 30 days after release. Okay, thank you.
Thank you, Judge.
Court does call the case People versus Phoenix Barnes.
Good morning, Your Honor. Raymond Cook for the people.
Good morning, Your Honor. Christina Saxon for Phoenix Barnes.
Your name, sir?
Mel
Bradburn. Barnes? What's your name, sir?
Mel Bradburn.
All right, just hold him there because we're having enough problems getting people out. We'll just find the file. Yeah.
That's Mr. Miller's case, Your Honor.
Okay, I apologize. So this is Mr. Bradburn,
Okay,
which is.
so
the
I'll
gentleman in
call.
front of-
I'll call the case of the People versus Jamal Bradburn. You're good, sir. Where's the beer guy? Oh, here he is.
Morning, Your Honor. Jay Greg Miller, P58658. On behalf of Mr. Bradburn.
He's already stated his. All right, what are we doing?
Your Honor, last time we were here, we're still waiting for that one crucial piece we need of evidence to set this for exam. It's my understanding we still don't have that.
What is the
report, Your Honor?
It's
a legible copy.
They do the carbon copies, and unfortunately, when they scan it at times,
And we still don't have it? Well, let me ask this. Is it your copy? Can you read your copy? Or you can't read your copy?
as much as I need to.
But you can't read your copy?
Your Honor, and if the court remembers up last, we were here at the sidebar. The one crucial part where it says no damage is checked no, no, no on the copy I can read, but the rest of it's kind of illegible. So it's not very fruitful for defense to be able to hold an exam. Because it appears to list no damage to the victim from my copy.
Is this the only thing holding him?
Yes, Your Honor.
And I realize, Mr. Kennedy, you made the request. Do we know what the delay is?
Working with hospital. In another copy of that same report. I don't know.
So do they want to be subpoenaed in? I mean, I will do what needs to happen. I mean, he can't sit here and that's. I mean, I'm not blaming you. I'm just saying people need to understand. So here's what I'm going to do. Realizing that discovery is not complete, but there's just this one issue. I'm going to set an exam for him. Would you have your witnesses available the 18th?
We'll do our best.
Preliminary examination in person will be set August 18th, 2020, 9 a.m. for me. And Mr. Miller, if you want a subpoena for the holder of those records, you can submit it to my office for my signature.
Thank you, Your Honor.
Court calls case versus Gene Hosford.
Morning, Your Honor, members of the people.
Morning, Your Honor. Dan Guerin on behalf of Ms. Hosford stepping forward. Gene, can you state your name?
Gene Hosford.
Thank you.
Your Honor, there should be a green sheet in your file. I'm asking for an adjournment. There appears to be negotiation. We're waiting on a restitution number. And of course, I have a travel request at the appropriate time.
Oh, you can go wherever you want.
Thank you.
Oh, no.
My wife will appreciate that. Thank
What do you want, the 27th or the 3rd?
3rd, please.
3rd. Adjourn the matter out to September 3rd, 2026, 9 a.m. Esteban.
Your Honor, Ms. Hosford is asking to go to a pre-planned trip to New Mexico from the 18th of August to the 30th of August.
Beautiful state.
Beautiful state, indeed.
From what time?
8th to the 30th, Your Honor.
Okay. It's going to see the state.
Anniversary trip and
well, congrats.
Go to the Santa Fe Opera. My interning.
Your granddaughter, is it?
Yeah.
Fantastic. Well, congratulations on the anniversary and permission to travel.
Oh, it's not my anniversary.
No.
Oh. No, I do that. I celebrate anniversaries all over.
Sure.
It's okay, man. Permission to travel.
Thank you, Your Honor.
Thank you.
Thank you. Court calls the case of the people versus Dontrell Smith.
Good afternoon, Your Honor, or good morning, Your Honor.
Assistant Public Defender Zach Finney with it on behalf of Mr. Smith, who is present via Zoom, I appear.
Mr. Smith, can you state your name, please?
Dontrell Smith.
Got it.
Your Honor, you should be in possession of a report that Mr. Smith is still incompetent but restorable to stand.
July 21st.
Yes, Your Honor. So we would be requesting an adjournment for that purpose.
All right.
Can I have a
court will find that it is still incompetent to stand trial, would set a competent
Oh, that's so
hearing
that might be the
for November 5th, 2026, 9 a.m. bond contingency.
Thank you, Your Honor.
Court calls case people versus Phoenix Orange.
Your Honor, Raymond Cook for the people.
Good morning, Your Honor. Christina Saxon for Phoenix Born.
Your name?
Denise Bornes.
All right, what are we doing?
Honor, um, I have secured the evaluator.
Ms. Saxon,
who's
I can't make
waiting
out
on
what you're
the
saying. You broke
approval
up.
From. Your Honor, I have the evaluator who can do his evaluation on Friday, but I'm waiting on the approval from IDSO.
All right, so what would you like me to do? Because we still haven't addressed his bond violation.
Could we have to September 3rd?
All right.
Your Honor, may I have a house arrest?
Me what?
House arrest. Can I get put on house arrest? Bond?
You be put on house arrest? I'll entertain a motion, but I'll entertain a written motion because I've got to still address this bond violation. I've not addressed that yet.
Okay, Your Honor.
Today's courtroom session was filled with case dismissals, guilty pleas, unexpected courtroom humor, and several moments where the judge had to make important decisions about bench warrants and defendants who failed to appear. The session moved quickly through a long list of cases. Early on, several defendants had their cases dismissed because the prosecution was unable to proceed. In multiple cases, the defense requested dismissal, and the judge granted those motions without prejudice. One case even involved a sign language interpreter who was properly sworn in before the court determined that the prosecution could not proceed. The same pattern continued through several more cases. Anthony Johnson, Muhammad, Jason Pope, Kyle Sowski, Chance Baylor, Nathaniel Flanagan, and Angela Hayes all had cases dismissed after prosecutors indicated they were unable to move forward. In the case involving Breonna Force, the defendant was not present because she was reportedly traveling from Detroit, and the judge ultimately allowed the case to be dismissed rather than issuing a bench warrant. But the courtroom wasn't completely serious. The judge repeatedly joked with attorneys about their clients' appearances and even made a comment about one group of defendants looking like they were dressed for a picnic. Those lighter moments gave the lengthy docket a surprisingly relaxed atmosphere. One defendant, Lola Lambo, had a much simpler outcome. She admitted responsibility for double parking a vehicle and was ordered to pay $180 in fines and costs. When the judge asked when she could pay, her answer was immediate. She could pay that same day. The judge clearly appreciated the straightforward response, joking that it was exactly the answer he wanted to hear. Then came one of the more serious cases of the hearing, involving Jalen Watson. He agreed to plead guilty to carrying a weapon while under the influence and operating while visibly impaired. The court carefully went through his rights and the consequences of the plea. Watson acknowledged that he had been driving after consuming alcohol, that he had been stopped because he was swerving, and that a blood draw showed a .11 result. He also admitted that he had a firearm in his glove compartment and did not have authority to carry it in that manner. The judge accepted his guilty pleas, dismissed the first count under the agreement, and referred him for alcohol screening, assessment, and a victim impact panel. Sentencing was scheduled for September 9th, 2026, with bond continuing under its conditions. Another defendant, Devontae Smith, came before the court with two cases. The judge addressed outstanding bench warrants that had been issued after Smith entered an exclusion zone, despite a prior warning. However, because the prosecution was unable to proceed, the judge canceled the warrants and dismissed both cases. The hearing then took an